Well, good morning, everybody, and welcome to this edition of the Radcliffe Chambers Junior Programme. My name is Natalie Pratt, and I am one of the junior tenants in Chambers, and I am joined this morning by Matthew Mills, who is also one of the juniors. As you are all here, you've probably guessed the topic for today is charities, and Matt will be talking about permanent endowment, and I will then be following up afterwards with a review of recent developments in charity law.
Well, good morning, everyone. As Natalie said, I'm Matt Mills, and I'm here to talk to you about charitable permanent endowment. Now, I've picked this topic for three reasons. Firstly, there's a surprisingly limited amount of case law or commentary on it, so I'm hoping to fill a gap. Secondly, the pandemic has put a lot of pressure on charities, particularly smaller ones, to spend their permanent endowment. And thirdly, in the last 2 months alone, we've had a reported judgment, some new draft guidance from the Commission, and a draft bill in Parliament, all of which touch on the topic. So with those reasons in mind, I propose to cover 5 things today. Firstly, what is permanent endowment? Secondly, how do you know if a charity has it? Thirdly, if a charity does have it, what does that mean for the trustees? Fourthly, how can trustees lawfully spend permanent endowment? And fifthly, what are the upcoming changes in the law and guidance? All right, let's start at the beginning. What is permanent endowment? In its current form, Section 353(3) of the Charities Act defines it as property held subject to a restriction on its being expended for the purposes of the charity. It's basically any property that the charity cannot freely spend. Now, there are 5 important points to bear in mind with this definition. Firstly, some Commission guidance uses phrases like designated land or specie land when they're really talking about certain types of permanent endowment. To keep things simple, I'll just refer to permanent endowment throughout this talk. Secondly, the restriction on spending does not need to be absolute for the asset to be permanent endowment. For example, the restriction might only limit the type of investments that can be made. For example, a clause may only allow trustees to invest in listed companies. Or the restriction might only last for a limited time, for example, 20 years, or until the property is no longer needed for the charity's purposes. So somewhat confusingly, that means that permanent endowment doesn't actually need to be permanent, although obviously the words permanent, forever, in perpetuity are a pretty good indication. Third point to bear in mind is that don't forget one asset can be both permanent endowment and expendable capital. For example, if trustees purchase a property with 50% endowment funds and 50% capital assets, that will be both. But when the trustees come to sell the property, they need to keep back the 50% that comes from the endowment and reinvest it. They can't simply spend it on the charity's purposes. Fourth point. The Commission distinguishes 2 types of permanent endowment. Firstly, investment permanent endowment. So that's capital which is used to produce an income, but which you don't spend itself. For example, this might be a fund of shares or some cash. The second type is functional permanent endowment. Now, this is property which is used for a specific purpose of the charity. Most examples are land, so things like village halls, recreation grounds, museums, stately homes, but it can be other things like significant works of art. Fifthly, don't forget it's perfectly possible for one charity to have more than one permanent endowment. For example, a school may hold its premises as functional permanent endowment, but also have a separate investment fund for a scholarship, which is held on investment permanent endowment. So that's what permanent endowment is, but how do you know if a charity has it? In my view, you should consider 4 main things, some of which might point towards endowment, some of which might point away. As always, the starting point is to look at the governing document and see if there are any restrictions on spending any assets. Now, make sure you look for both express restrictions, don't spend this, and implied restrictions. For example, a clause may allow the trustees to spend the income from an asset, but say nothing about the capital. If the governing document's not clear, though, you can consider historic evidence showing how the relevant assets have been used in the past. For example, you could consider deeds or wills that created the endowment, or conveyances or accounts, to show how the asset has been used over time. But don't forget, the previous trustees might have just got it wrong, or they might simply have not needed to spend the capital of that asset at that particular time. So I'd suggest you take this type of evidence with a little bit of a pinch of salt. Thirdly, you could try and rely on a presumption. Section 353(3) effectively creates a presumption that unless assets can be spent, then it's endowment. But fourthly, and somewhat unhelpfully, the Commission takes the view that it will err on the side of allowing assets to be spent, and says trustees don't need to find a clear power to spend capital to avoid the limits on endowment. So unfortunately, 3 and 4 really point in different directions, but hopefully with 1 and 2, you should have a general flavour for where you're going, and then you can apply 3 or 4 as appropriate. All right, you've decided your charity does have a permanent endowment fund, but what does that mean in practice for the trustees? Unfortunately, the short answer is there is no short answer. As the Law Commission put it, it's unhelpful to assert that permanent endowment can or cannot always be used in a particular way. Rather, the relevant question in any particular case is whether this specific property, which is subject to this specific restriction, can be used in a particular way. So really, that's the model that you need to apply when your clients ask you questions. You need to look at the specific restrictions in the governing document and look at the specific assets and see what they can do. But in very general terms, here's the high-level answer. If a charity has investment permanent endowment, then the trustees can sell the investment as long as they're using that fund to then buy a replacement. They can't simply sell it and spend the proceeds on the charity. However, if the charity has functional permanent endowment, the rule's slightly tighter. The trustees may be able to sell the assets, but they may not at all. For example, if the property is so closely connected to the purpose of the charity. For example, a trust of 10 Downing Street, you couldn't simply sell 10 Downing Street and buy another fancy apartment in London. Clearly, 10 Downing Street is the essence of that charitable trust. But if you are allowed to sell the functional permanent endowment, again, you'd have to make sure you replace it. You couldn't simply spend it on income. But in practice, the most common question that trustees are likely to have is, can I spend my charity's permanent endowment? Now, there are many reasons why this might be a good idea. For example, the cost of maintaining the endowment might outweigh the income it produces. For example, if the asset's an old and particularly poorly built building, they may have very high maintenance costs, and the trustees may be unable to let it at all or for profit. Secondly, the charity may have overwhelmingly pressing short-term cash needs, for example, because of COVID. As you can imagine, this has been quite a common reason submitted to the Commission in the last year or so. And in fact, the Commission's COVID guidance explicitly acknowledges that struggling charities can consider spending their endowment if they've got no other way of raising funds. A third example I found in the Law Commission's report is pretty niche, but quite cool. If a charity's been set up to relieve a particular illness and a new cure is produced, the trustees may wish to basically sell their endowment so they can bulk order the cure and try to eradicate the disease. That's obviously quite niche, but it gives you an example of the types of things that might be appropriate. So that's the why, but how can trustees spend their endowment? Well, there are 4 main options. Firstly, the trustees could use the statutory powers in sections 281 to 284 of the Charities Act. Secondly, trustees could seek an order from the Commission permitting them to spend it. Thirdly, the trustees could seek a scheme. And fourthly, the trustees could adopt what's called a total return approach to the investment of the charity's endowment. Now, I'll say a bit about those 4 in a minute, but before I do that, I thought I should mention 2 dead ends. Firstly, the Commission has confirmed that charities cannot use the power in section 280 of the Charities Act to amend the purposes to allow endowment to be spent. That's outside the scope of the power. And secondly, statute confirms that charities can only make social investments or program-related investments with their permanent endowment if those investments would not contradict the restrictions on spending. Now, that's a bit garbled. What does that mean? Well, in practice, this means that trustees are likely only to be able to make profit-making social investments with their endowment. In practice, that's going to make it very difficult to make many types of social investments. So be careful about using that as a route. to effectively spending endowment. But let's then turn to what you can do. And I'll start with the most common method for spending endowment, the statutory powers. At present, this is only open to unincorporated charities, although, as I'll mention in a bit, the Charities Bill will amend that in due course. Sections 281 and 282 provide two separate regimes. The simpler process in section 281 applies if one of three conditions is met. Either the charity had a gross income in the last year of £1,000 or less, or the endowment itself is worth £10,000 or less, or the endowment fund was not entirely given by one or more donors in one go. Now, this last restriction is a bit of an unusual one, and even the Commission confirmed it doesn't really know what this means. But in practical terms, this is likely to be relevant in two situations. Firstly, if the charity has created its own endowment by accumulating income and then setting it aside, or if the charity's added together different donations from different people and then called that an endowment. But outside of that situation, then most situations, the endowment will be entirely given. If any of those criteria apply, then the trustees can simply pass a resolution freeing all or part of the endowment from the restrictions. Now, to make that decision, the trustees must be satisfied of quite a chunky paragraph, and I've put it on the screen. But in a nutshell, what this means is the purposes of the endowment trust could be carried out more effectively by spending the capital. So if you fall into one of those three situations, the trustees are satisfied, that's it, you pass the resolution and crack on. But if you don't fall within those three situations, in other words, your charity had an income of more than £1,000, the fund's worth more than 10,000, and it was entirely given by one person, then you can still pass the resolution, but you need to get the Commission's consent before you can act on it. And this is where the Section 282 procedure comes into it. I'll make 4 points about the process of getting that consent, and then 3 points about what the Commission will look for. So turning to the procedure. Trustees can apply to the Commission for consent using the online application form that I've put on the slide. Obviously, trustees should attach a copy of the resolution and the minutes from that meeting because the Commission needs to see what the trustees decided and why. Generally, the Commission must make its decision within 3 months of receiving your application. So if you're on a tight time frame, it's worth checking with the Commission when it received your application so you know the outer limit of the period. Finally, in more complicated cases, the Commission may ask the trustees to provide more information or may even direct the trustees to give public notice of the resolution and invite representations. So that's the procedure. But what about the substance? Well, the general rule is that the Commission will only give its consent if the implementation of the resolution would accord with the spirit of the gift or gifts which created the endowment. In practice, this means the Commission is unlikely to give its consent to allow functional permanent endowment to be sold under a Section 282 resolution. In reality, the trustees are likely to need to modify the charity's purposes instead in that situation. Turning to the evidence, the Commission will want to consider 3 main things. Firstly, the charity's regulatory history. Understandably, well-behaved and compliant charities are treated more leniently than naughty charities. Secondly, because Section 284(2)A requires the Commission to consider the spirit of the gifts, the Commission will want to see any available evidence about the intentions of the people who first created the endowment. So make sure you try contacting them or their descendants or their representatives before you submit your application. Thirdly, the Commission will want to consider any changes in the circumstances of the charity since the endowment was created. Now, there's basically 2 aspects to this. First, it's the financial side. So you should provide evidence of the charity's income and the value of the endowment. But the second element is really a market review. The Charity Commission wants to know how many beneficiaries do you have? What are their needs? And what are the wider social, economic, and legal environment in which the charity operates? That's the type of evidence that the Commission will want to see when deciding whether to approve. That's the main option then. If unusually this route's not open to trustees, then the trustees could consider asking the Commission to make an order instead, which permits them to spend the endowment. The Commission suggested this might be appropriate, for example, if the social and economic circumstances haven't changed enough since the endowment was created, but there are still good reasons to spend it. When considering whether to make an order, the general test is that the Commission will ask whether it would be expedient in the interests of the charity. In practice, this is pretty similar to the best interests test, so those are the kind of ideas that should be at the forefront of your mind. Helpfully, in its operational guidance, the Commission sets out 9 factors which it will consider. Now, I haven't pasted them onto the slide because it would take up too much space, but if you're going to make this type of application, I'd recommend you look up that particular paragraph in advance and see if you can address all the points. Practically, though, the Commission will likely expect the trustees to have explored other options before coming to ask for an order. For example, the Commission might want you to see if you could accumulate your own income or get an interest-free loan from a bank, or if you can get a grant from a grant-making charity. So you should probably include evidence of why those are not possible in the application. In most cases, the Commission will make an order only on the condition that the amount of endowment that is spent is replaced. But in some circumstances, the Commission may waive this requirement. For example, if the permanent endowment is going to be spent to buy something that will benefit the charity for 75 years or more, then you might not need to replace it. In practice, that's probably limited to things like buildings, but there may be some other examples. Another example is if the only hope the charity has of staying afloat financially is by spending its endowment, the Commission might relieve you from needing to repay it. But even in that situation, the trustees must persuade the Commission the charity has a viable future, and it's not just going to spend the endowment and then dissolve. Finally, though, it's worth bearing in mind when the Commission will not make an order on permanent endowment. Firstly, again, if the charity has a poor financial management history or poor regulatory compliance history, you might find some pushback. Secondly, if the order would override an express provision in the governing document, then the Commission won't make an order. For example, if the governing document actually says you cannot spend X, the Commission's not going to use an order here. Thirdly, if the order would change the charity's purposes, then the Commission won't do it. In either of those last 2 situations, what you're likely to need is a scheme. So let's talk about schemes. The scheme is most likely to be relevant if the trustees want to spend functional permanent endowment, where the property is part of the charity's purposes. Remember my 10 Downing Street example. The Commission has confirmed that it's happy to make a scheme in this situation if there are good grounds to do so. In practice, this is probably just another way of saying the general test that it's expedient in the interests of the charity. Let me give you some examples, though, of when this might be appropriate. For example, a scheme may be made if the trustees want to sell one of the properties owned by the charity to be able to afford the refurbishment of all of the others. Or if the trustees want to use the sale proceeds to fund the wider purposes of the charity's activities, rather than just one of them. Or if the trustees want to lift an outdated restriction, or if the purposes themselves have now become impractical or outdated. If you're thinking about applying for a scheme, I'd recommend that you check out OG 500, which is the Commission's operational guidance on this topic, because it gives very detailed guidance on the practice and procedure. The fourth and final option is a little different to the others. Since 2014, trustees have been able to adopt what's called a total investment return policy under the Charities Total Return Regulations of 2013. In a nutshell, this allows trustees to treat the increase in value of the underlying asset as part of the income, and then effectively borrow up to 10% of the value of the endowment. That's obviously not very much, but it's still something if you've got no other options. Now, the rules here are quite techy, so I'd suggest that you take specialist advice before making any decisions, but I'll try and summarize the 5 key steps for you. Firstly, obviously, the first thing you need to do is make a resolution to adopt a total return investment policy. That policy is quite flexible. It can apply to all of the endowment, part of the endowment, or to one of multiple endowments. But trustees should only pass the resolution if they're satisfied that it's in the interests of the charity to do so. If they do pass the resolution, then that resolution must record the date, the value of the endowment at that point, and the amount of unapplied income which the trustees have at that point. But please bear this in mind. these starting figures cannot be changed unless the entire policy is revoked. So I'd suggest if the assets are quite substantial or complicated, that you seek a professional valuation before going through the resolution thing. Interestingly though, once you've passed the resolution, you don't need to notify the Commission. You can just crack on. So that's the first step, pass the resolution. Once the resolution's been passed, what this means is that each year the trustees can add up the actual income and the increase in the capital value of the endowment. And you call this the total return. The Commission's regulations state that unless it's unnecessary or inappropriate, trustees should seek professional advice here, because we're really talking about technical points of accounting. Having received that advice, the trustees can then allocate up to 10% of the value of the endowment to the current assets. But when deciding what to do, the trustees must exercise reasonable skill and care, and in particular, not prejudice the ability of the charity to further its purposes either now or in the future. Crucially, as I mentioned, this is really about borrowing. Any sums taken must be replaced on a pound-for-pound basis over the period that the trustees reasonably determine. Once you've made a decision for that particular year, you've then got to record it with your reasons in the annual accounts or reports. As I said, this is quite techy, and if it's all going a bit pear-shaped, don't worry, you can revoke a total return investment policy and just go back to normal. So that's the state of play of the current law and guidance. But as I said at the start of the webinar, this area of law is undergoing some fairly substantial changes at the moment. None of these changes has yet been finalised, but I thought it would be helpful for me to summarise for you where things are as of June 2021. First things first, the Commission has recently held a consultation on some new draft guidance on ethical or responsible investments. Trustees have basically been telling the Commission that they feel unable to make ethical investments because they believe their primary duty is to maximise financial returns. Now, you can find the Commission's consultation responses on that link, but the key point for my presentation today is that in the legal underpinning document, the Commission seems to suggest that even after the guidance has been changed to be more flexible, charity trustees will still be unable to invest permanent endowment ethically. In other words, they must still focus on maximising the financial return. This was a point made to Mr. Justice Michael Green in the Butler Sloss case, which I'll talk about in a moment. So do bear in mind, even if the guidance changes, this may not help permanent endowment investments. The second change is that case I've just mentioned. By coincidence, a week into the Charity Commission's consultation on ethical investments, Mr. Justice Michael Green gave permission to 2 charities to essentially seek judicial directions on the current rules on ethical investments. If this case goes ahead, it would essentially allow the High Court to revisit the infamous Harries case from 30 years ago. Now, I can't find any updates on how the case is progressing, so do keep your eyes peeled for the next year or so. It's also possible that until this case is decided, the Commission might hold fire on publishing a final version of its ethical investments guidance. But you never know, one might come before the other. But third, and most importantly, clauses 9 to 13 of the Charities Bill will make 4 key changes to permanent endowment law. Firstly, the bill will amend the statutory definition of permanent endowment, so it now reads, property is permanent endowment if it's subject to a restriction on being expended, which distinguishes between income and capital. The explanatory notes make clear that this is more about streamlining and clarifying rather than making any fundamental changes, but do bear this in mind. Secondly, the bill will make various amendments to the Section 282 procedure. Remember, that was the way that you asked the Commission for consent to a resolution to spend endowment. The first change is an important one. Incorporated charities will now be able to use it. Also, helpfully, we're getting rid of the entirely given requirement, so trustees won't need to worry about how their endowment was created. The financial threshold will also be changed. Remember, at the moment, the threshold is £10,000 or less for the value of the endowment. That will be increased to £25,000 or less. And we're getting rid of the requirement for any income. The only question will be, is the endowment worth £25,000 or less? And finally, the period within which the Commission must reply will be reduced from 3 months to 60 days. So that will speed things up a bit. The third change is that the bill will amend the rules on total return investments to allow social investments, even if they make a loss. So this is a small way that the bill will impact ethical investments. Finally, though, and most radically, the bill will introduce a new power for trustees to borrow from their permanent endowment. This will be inserted into sections 284A to D of the Charities Act. And in summary, it will allow trustees to borrow up to 25% of the endowment if they believe is expedient in light of the charity's purposes. This can be split over more than one loan, but the overall pool of loans must not exceed 25% of the value of the endowment. Once it's been borrowed, the money is free from the endowment restrictions and can be spent freely, as if it were income. But the trustees must repay it within 20 years. And they can, but don't have to, choose to add a bit extra to replace the estimated increase in the capital value over that period. However, trustees can't use a second loan to pay off a first loan from the endowment. So although you can have more than one loan, you can't simply use number 2 to pay off number 1, number 3 to pay off number 2. That's cheating. Also, it's possible for the governing document to exclude this power. So don't just assume that this will automatically apply in every case. Finally, if the trustees think they're going to be unable to repay all of the loan, they're required to apply to the Commission for directions. Now, the Commission's given a very broad remit here in what it can do, but it's explicitly said that the Commission can extend the period for repayment or simply write the loan off. And we haven't yet had any guidance from the Commission, but that's what we'll obviously need to keep our eyes peeled for, because that will tell us how the Commission will approach these situations. So we've got quite a lot to look forward to over the next year for permanent endowments, but in the much shorter term, if you have any questions for me, please do type them in.
So I have spent most of the last year either sat in this room or out riding my bike. And I have definitely not spent it at drinks receptions, drinking wine and eating canapés and catching up with everybody on recent events in charity law. And it's probably not quite time for wine just yet, although it is the Chancery Bar, so we're almost there probably. So I thought instead what we might do is we might grab a coffee. And if the eagle-eyed, there we go, Matt's got his mug, the eagle-eyed will see that I'm a Derby County fan, someone has to be. So I thought we could all grab a coffee and have a catch up with some recent events in charity law and have a think about the things that we might have been talking about had we been meeting in person and hosting these events over drinks and canapes. And so with that in mind, I think there are probably 2 things that we would be thinking about and talking about together at drinks receptions at the moment. So in recent weeks, we've had 2 important cases that have been handed down. So the first is the Nuffield Health and London Borough of Merton decision. So this is a decision of the Court of Appeal on the 28th of May. And then Matt has already alerted us to the Butler Schloss decision against Charity Commission, and this was handed down on the 14th of April. And so I think these are probably the 2 big topics of conversation from the last couple of weeks that we would have been thinking about. So I'm going to do things perhaps the wrong way around. I'm going to go first with my headline act, and I am going to talk about the Nuffield Health decision. Now, this is one of those charity cases that sort of comes to us in disguise, but it comes to us in the familiar disguise of ratings. And so to recap on the context, what we have is the Local Government Finance Act of 1988, the relevant section, section 43, subsection 6A, so put it here on the slide. And this section provides for a mandatory 80% relief from non-domestic rates, so from business rates, where the ratepayer is a charity or trustees for a charity, and the property is wholly or mainly used for charitable purposes, whether those be the purposes of that charity or of that charity and other charities. Now, the ratings regime does produce charitable cases fairly often. You might remember the most recent one, the most recent tranche of challenge coming from the NHS Foundation Trusts. But Nuffield Health is the first time in quite a long time that the Court of Appeal had a proper chance to really think about and review the public benefit requirement. So then, what of the Nuffield Health case? Well, I start perhaps in true charity fashion by declaring an interest. I am a devoted member of my local Nuffield Health gym. My chubby cheeks wouldn't let you have that believed, but I am. This does not affect my reading of the case, and other good gyms are available. However, Nuffield Health. Nuffield Health is a company limited by guarantee, and it is a registered charity. Now, its principal object in its governing document is to advance, promote, and maintain health and healthcare of all descriptions, and to prevent, relieve, and cure sickness and ill health of any kind, all for the public benefit. Now, throughout its entire group, Nuffield Health owns and operates 31 hospitals, 112 fitness and wellbeing centres, and 5 medical centres. And then it also operates over 200 gyms and health assessment facilities in workplaces across the UK. Now, Nuffield Health is a trading charity. In 2017, its group turnover was around or just over £909 million. And generally speaking, the fees that it charges for its services and the fees that it charges for the provision of its facilities, so things like membership fees, they generally cover the costs of those services and then generate a small surplus for reinvestment. So that is an introduction to Nuffield Health. The facility in question in this particular case then, as the name suggests, is located in the London Borough of Merton. The particular premises was a gym. It also had a swimming pool and all the things that go with that. So your sauna and your steam rooms, a couple of treatment rooms, and a members only creche, or at least a creche that's available only to members' children. It also had a members only car park. And you could access these facilities for the fee of £80 per calendar month or £852 a year if you want to pay it all in one go and sign up to a 12-month contract. But if you want to use the creche or you want your child to use the creche perhaps, that will cost or incur an additional fee. Now, this particular site was acquired by Nuffield Health in August 2016. And Nuffield Health then applied to the local authority for their mandatory rates relief. And that was initially given, although the discretionary relief, so the additional 20%, was refused. However, the local authority then withdrew the mandatory relief in November 2016, and Nuffield Health issued proceedings. Now, the case originally came before Stuart Isaacs QC, sitting as a deputy judge of the High Court, and I think it was last January it came before him. And he declared that Nuffield Health was entitled to the 80% mandatory relief and also ordered a repayment to Nuffield Health of the business rates that it had overpaid as a result of his finding. And I think the sum was somewhere around £930,000. So it wasn't an insignificant amount of money by any stretch. Okay, so Merton, local authority, are unhappy with that finding and they appeal. And there are 4 grounds of appeal. So the first ground, Merton say, the judge was wrong to hold that Nuffield Health was not required to show that the premises were being used for the public benefit. And so essentially the argument that's being put forward here by Merton is that a charity, such as Nuffield Health, must show that the rateable premises in question is itself being used for the public benefit. So Merton say it's not enough just to say, we're a charity, we have charitable purposes, we are using this premises for those purposes, and therefore that's fine. We're entitled to our mandatory ratings relief. Merton say, absolutely not. You must show public benefit at any given site in order to qualify for your mandatory ratings relief. The second ground of appeal, Merton say the judge failed to apply the correct standard of public benefit for Nuffield Health's use of the premises. And so the argument here that Merton are making is that if your charity falls outside of your so-called core charities, so health charities, relief of poverty, education, Merton is saying actually to meet the public benefit requirement, you must have a much wider reach of benefit in order to tick this box. And Merton is saying this is especially the case if you have a recreational charity or a charity that is of general public utility. You must have a much wider reach of benefit in order to meet the public benefit test. The third ground of appeal, so Merton say that even if the judge is applying the correct standard, he erred in his evaluation of whether the public benefit requirement was satisfied. So even if they're wrong on ground 2, and we are just using the usual public benefit requirement, Merton is saying it's been improperly applied and there is in fact no public benefit at this site. And then the fourth ground of appeal, the judge was wrong to conclude that the premises were not being used wholly or mainly for fundraising. So essentially Merton is saying, well, look, these membership fees, they're generating a surplus. Essentially what we have here is a commercial fundraising activity. And this surplus income is being used to subsidize the pursuit of charitable objects at other sites. And they say that means that this does not qualify for ratings relief, and they're relying on the Oxfam case. And we're making that argument. So what is decided in the Court of Appeal? Well, the appeal is dismissed, and Nuffield Health are entitled to their mandatory 80% ratings relief. The appeal is dismissed on ground 1, but it's not unanimous. It's a ratio of 2 to 1. So Lord Justices Nugee and Peter Jackson are dismissing the appeal, and Lord Justice David Richards would have allowed it on ground 1. And the decision here of the majority is that the public benefit requirement is to be applied to the purposes of the charity and not to the activities carried on at the individual property. And therefore, as a result of that, the appeal is dismissed. Now, technically, this means that the other grounds don't actually arise, although there's a debate as to whether ground 4 does still arise or not, but certainly grounds 2 and 3 don't actually arise. But because Lord Justice David Richards would have allowed the appeal on ground 1, he goes on to consider grounds 2 and 3. He says some really interesting things, and actually ground 3 is particularly interesting for charity lawyers. But in terms of the second ground, as I've said, didn't really arise because ground 1, the appeal was dismissed. However, both justices who dismissed the appeal did indicate that they would have agreed with Lord Justice David Richards on this ground. And what he is saying is that there is no hard-edged rule that some charities are required to be for the public at large, or those in need of the charity's provision, and in particular with a focus on recreational charities, or those of general public utility. And then he goes on to say, well, in any event, Nuffield Health is not a recreational charity, and even if it were, subsection 5 of the 2011 Act preserves the public benefit requirement without reference to the other provisions in section 5. So ground 2, as far as all 3 justices were concerned, was pretty much a non-starter. Ground 3 then is particularly interesting. So again, doesn't arise really because the appeal is dismissed on ground 1. However, both Lord Justices Peter Jackson and Nugee did agree with David Richards, or Lord Justice David Richards, and he would have allowed the appeal on this ground. And so therefore the appeal would have been allowed, but for this technical construction of the ratings legislation. So actually Nuffield Health would have failed on the public benefit issue here. And so the decision on ground 3 of Lord Justice David Richards, and which would have been adopted by the other 2 justices, was that Nuffield Health could not show that the membership fees did not exclude those of modest means, or that it was satisfying a need that was not otherwise met from other market providers, and it only provided limited and token benefits to non-members, and that was insufficient to satisfy the requirement for charitable use. And on ground 4 then, there was a slight division of opinion. So Lord Justice Nugee was inclined very much towards the view that the premises were used for, or wholly used for, Nuffield Health's charitable purposes. And he said, well, just because there's a generation of surplus income, that doesn't mean that it's being used for other means. If he was wrong on that ground, he then adopted, or sorry, if he was wrong on that reasoning, he adopted the reasoning of the other 2 justices. And their reasoning was that there just simply was no evidence of the actual income and surplus that was generated by the operations of the premises. That evidence wasn't before the court. There also wasn't any evidence of the use to which Nuffield Health put any of this surplus, or whether this surplus was being used to subsidise Nuffield Health's other charitable objects at other sites. And so in the absence of that evidence, there couldn't really be a conclusive decision on ground 4. And in any event, it doesn't actually follow that the generation of a surplus means that your premises are being used for fundraising. So actually, hopefully we can see that there are two particularly interesting grounds that we might need to have a closer look at. So ground one, on the question of whether rateable premises need to show public benefit or if it's just the charity generally. And ground three, on the question whether the premises were in fact being used for the public benefit, which all the justices agreed it was not, although not that that affected the outcome of the appeal in the circumstances. So we look a little bit more closely at ground one. So as I've mentioned, ground one really was a question of construction, and the construction of section 43, subsection 6A of the ratings legislation, and what it means for a property to be used wholly or mainly for charitable purposes. Now, both Lord Justice Nugee and Jackson, and in particular Nugee, spend a lot of time tracing through the ratings regulation, the ratings legislation, and looking at its various iterations over the years, and considering the purpose and intent behind the legislation and the regime as a whole. And as Lord Justice Nugee puts it, I think it's at paragraph 130, he says there are two possible constructions of this section. He says the first possible construction is that the charity must be using the property for a purpose which is one of its charitable purposes. So that's option one. And option number two for construction, the charity must be using the property for a purpose which is by itself a charitable purpose, i.e. there would be a need to show public benefit at each particular site. Now, as I've outlined and as we've seen, both Lord Justices Nugee and Jackson preferred option A. So they preferred the construction that the charity need only be using the property for a purpose, which is one of its charitable purposes. And along the way, there are two important things that are said. So first, at paragraph 99, the public benefit requirement is subsumed into the status of the charity ratepayer. We don't have the ratings authority asking the question of public benefit. That question is already determined by the determination of the charitable status of the charity occupying the premises. And the second interesting thing at paragraph 138, broadly along the same lines, registration of a charity is conclusive of the charitable status of its purposes, and provided the charity is in fact using its premises for those purposes, and that is sufficient for rating purposes and for qualification for mandatory relief from business rates. Now, just sticking with ground one briefly for a moment more, there are three practical considerations that Lord Justice Nugee had in mind when reaching his conclusion on this particular construction of section 43. And he says, well, that this particular construction will generate consistency across local authorities. And when you think that this is mandatory ratings relief, and we're not dealing here with the discretionary relief, you would imagine that actually consistency is a desirable aim and outcome here. The second practical consideration, assessment of public benefit upon this construction is left to the Charity Commission. It happens once, and it happens at the point at which the charity is registered as a charity. And you would imagine that the Commission are going to be much better placed to decide on whether a charity does. You'd imagine that the Commission is going to be much better placed to decide if a charity does exhibit public benefit, them being the specialist body and the regulator of charities. And it also avoids wasting resources and duplicating the task. So there's no point in having the Commission deciding if a charity exhibits public benefit and then having the ratings legislator or the ratings authority doing exactly the same thing and actually potentially coming up with a different result. That in itself must be undesirable. And then the third practical consideration is that the construction that was preferred by the court should hopefully prevent any anomalies where a charity is split across multiple sites. And actually Nugee here was warning of instances, and he had in mind particularly schools. There might be instances in which you have a charity split across multiple sites, but public benefit is only demonstrated or exhibited at some of those sites and not others. And if demonstration of public benefit is what is needed for your mandatory ratings relief, he says, well, surely there's a risk that these services are then going to be rotated between sites just for the purposes of qualifying for ratings relief. And that in itself is probably going to be undesirable and could actually hinder the provision and the efficiency with which those services are being provided. So that takes us then to ground 3. And so again, ground 3 didn't arise because the appeal was dismissed on ground 1. But Lord Justice David Richards takes this ground head on because it is relevant for his decision, because he did not dismiss on ground 1. And as I've outlined, the other 2 justices were willing to agree and did adopt this reasoning. And so to look at ground 3, I think really you need to start by thinking back to the Independent Schools Council case. And I've quoted what I think is the relevant paragraph on the slide, so paragraph 244. So the first issue really when we're thinking about public benefit in Nuffield Health is whether those of modest means are excluded by virtue of the membership fees and the level at which those fees are set. And so in the Independent Schools Council case, we were told that provision for the poor going beyond a de minimis or token benefit may be present, but it is not necessarily enough. The level of provision for them, taken with benefits to the not so poor, who would otherwise be unable to afford the fees, must be at a level which equals or exceeds the minimum which any reasonable trustee could be expected to provide. Now, Nuffield Health supported the findings of the High Court judge and said that the court should defer to the trustees as to the minimum that is required to meet the threshold for demonstrating public benefit. And in particular, Nuffield Health was supporting what the judge said at paragraphs 41 to 42 in the High Court. And there the judge said, well, all these things that Merton are raising individually are not enough to prevent there being public benefit, and equally collectively are not enough to prevent public benefit. And the things that Merton were raising in that regard were the membership fees being at market rate and being set at such a level that they were intended to generate surplus. Also the fact that the membership fee was higher or set at a higher rate than other local facilities that had a comparable offering. Also the fact that you had to pay to use additional facilities such as the creche or to access things like the treatments at the gym. And also the absence or unavailability of free and reduced fee services to non-members. And also, as Merton was putting it, the limited and token free or reduced services offered at the premises as a whole. And so the High Court judge was saying, well, look, individually, this is not enough. Collectively, this is not enough. I still find there to be public benefit. Now, Lord Justice David Richards did not agree with that at all. And he said 3 quite important things along the way that we might need to bear in mind when we're considering public benefit in the future. So the first thing he said is that it really was for Nuffield Health to produce evidence that the membership fees did not exclude those of modest means. So if Nuffield Health's case is that, oh no, we demonstrate public benefit because we don't exclude people, they need to produce evidence to show that. And the judge was saying, I really expected to see evidence of the local demographic, their income, certainly their disposable income, and then we can assess whether these fees are excessive and whether people of modest means are in fact excluded. The second interesting thing that's said along the way is that the availability of these comparable commercial facilities at lower prices did mean that Nuffield Health could not really argue that it was satisfying a public need that would otherwise go unsatisfied. Now, the fact that the fees at these other facilities were lower does not in itself inform public benefit, but the fact that these facilities were on offer and they were cheaper, so they were more accessible, that really does prevent Nuffield Health from saying, well, look, we're offering a service that nobody else in the local community offers, therefore people need us. And the third quite interesting thing, which could cross across many sectors and not just the health and sort of gym recreational sector. So Nuffield Health couldn't rely on the provision of their services to non-members to demonstrate that the premises was being used for charitable purposes. So they offered things like free health MOTs a couple of times a year to members of the public. So you'd go in and have your blood pressure taken, and you'd be shown how to use a treadmill and things like that. And you'd get a free one-day gym pass thrown in. Or you'd have a meet the expert day, and you can go and speak to a dietitian or a personal trainer, and you might get a free 15-minute physio session. So things like that. So little bits to try and draw you in. And that's exactly what Lord Justice David Richards thought it was. It was a little bit of something to try and draw you in. These were just activities that are replicated across all the commercial operators, and really they could be inferred as being promotional rather than as anything, necessarily for the public benefit. And so he did say that these free and reduced fee offerings were very limited to the extent that they were token and did not meet the public benefit requirement. So we finished my exposition of Nuffield Health, I think, with the health warning on ground 3 from Lord Justice Peter Jackson at paragraph 124. So he says that while they may have succeeded under the ratings legislation, the fact that they did fail on ground 3 may not be without consequence in the context of charity law. Now, trustees are obliged to satisfy themselves in good faith that provision is for the public benefit. And if the situation at this particular gym is replicated across several hundred fitness centres and gyms, the organisation may face scrutiny through the Charity Commission. So he's rather dropping Nuffield Health in it there. So it does raise the question of whether Nuffield Health meets the public benefit test overall, especially if its bulk offering replicates that offered at the Merton site. And so it could be a question of watch this space, both for Nuffield Health and also for other charities that operate similar multi-site and, dare we say, quasi-commercial operations. And so that then is Nuffield Health, and something that I think we would have been talking about at our drinks receptions. The second case, Matt beat me to it on the second case, shows how important it is. Partner Schloss and the Charity Commission. So this case is notable, not necessarily because of what was decided, because it was only a permission case, but more likely because of what it has potentially unleashed. This could be the start of something quite important that we need to keep an eye on over the coming months and maybe over the next year or so. Now, the case was brought by the trustees of the Ashton Trust and the Mark Leonard Trust, and both of these trusts have the charitable purpose of environmental protection or improvement. And the trustees were seeking permission under section 115, sub 5, to bring charity proceedings. So they'd already asked the commission. The commission had said no, although the commission hadn't actually said no. The commission had said, we're going to put this on hold because we're about to give new updated guidance. But the High Court judge said, well, no, that's a refusal. So the commission have said no, hence having to ask the court for permission under subsection 5. So the trustees are seeking declaratory relief and directions regarding the nature and scope of their powers of investment and how they might discharge those powers where particular investments and investment policies might be inconsistent with or in conflict with its charitable objects. And so what was going on in practice is the trustees were proposing to adopt an investment policy that excluded investments that were not in line with the Paris Agreement, remembering that this is an environmental protection charity. But they did acknowledge that there was a significant risk that this might generate lower investment returns, certainly at least in the short term, perhaps in the long term, but there was definitely a short-term risk, and the trustees were alive to this. Now, as Matt's already indicated, we only really have one decision on these so-called ethical investments, and that decision is almost 30 years old. And so it's the Bishop of Oxford case, and I've put the relevant paragraph, or one of the important paragraphs, on the slide here. And I think it'd be fair to say that the court here took a very cautious view of so-called ethical or responsible investments. And the decision was very much that it would be a very rare occasion where the nature of an investment or the source of the money would actually hamper the pursuit of charitable objects. And any difficulty that's perceived of that nature really needs to be balanced against any potential financial loss that a charity might suffer by adopting sort of an exclusory investment policy. And also the greater the risk of financial detriment, the more convinced the trustees had to be that this ethical investment policy really was necessary, and without it, there really would be a difficulty in pursuing the charity's charitable objects. Now, over the years, arguably, some of the Commission guidance has been a bit lukewarm on the Bishop of Oxford case. And Matt's already pointed us to the fact that there is new draft guidance on now so-called responsible investments. I've put the link to it on the slide, and in particular, thinking about paragraph 2.1. And so paragraph 2.1 is telling us, remember it's only draft guidance, that you can decide that rather than just focusing on the financial return on an investment, your approach will also take into account your charity's purposes and values. And actually, it goes even further than that later on. And it says you can take a responsible investment approach even if there is no apparent direct conflict with your charity's charitable purposes, if you can show it's in the best interests of your charity. Now, extra rules apply to permanent endowment. Matt's already taken us through permanent endowment. And it's clear that at the moment, the Commission guidance is steering very much towards the direction of limiting the Bishop of Oxford case to permanent endowment, and then freeing off other trustees of other charities that aren't dealing with permanent endowment to make these so-called ethical or responsible investments. And really what we can see is the Commission are embracing investment in a modern age where trustees and beneficiaries of charities, and probably society generally, is a lot more aware and alive to the wider consequences of decisions that we make, and in this instance, investment decisions. So as Matt's already said, he's stolen my thunder. Permission was granted. Notwithstanding the fact that Commission said no, the court said yes, permission was granted, and two particularly important comments along the way. It can be safely said that these proposed proceedings raise highly topical issues that are seemingly unresolved by legal authority, remembering we only have that one. And it's clear that a further judgment of the court in this area will not only provide necessary protection to the trustees, but will also provide much needed clarity to charity trustees generally. And then on a more specific note to these particular charities, the proposed proceedings will conclusively and in a legally binding way resolve issues of real importance to the ongoing administration of these charities. So the reality of this case is that because the trustees have yet been unable to adopt this investment policy that they're keen on, and they're looking to the court for directions, there hasn't actually been any investment activity for the last year. And therefore the trustees want to crack on, they want to administer the charity, and they need a policy in place in order to allow them to do that. So as Matt says, watch this space. This will certainly be something that we need to keep up to date with. Be interesting to see who gets there first, whether it's the Commission or the court. I note from the Commission's website that it says that they are still carrying on with the consultation, irrespective of the High Court's decision. My understanding is that at the moment, the Commission are at the stage of reviewing consultation responses. So it may be that they get there first.
Thank you very much, Natalie. There's been a question for me while you've given your excellent talk, and I'll read it out. It's from Anonymous. Can investment permanent endowment be recategorized to be used as functional permanent endowment, i.e. selling commercial premises which are let out for rental income and using the proceeds to buy new premises for charitable activities? What consents would be necessary to do this? In my view, if the functional permanent endowment, the new premises, will not produce an income, then it may be difficult to justify doing this without amending the governing document. There's also practical reasons why the trustees should think carefully about imposing functional permanent endowment limits on themselves. So I'll take you through the legal bits first and the practical bits. So legally, if something is investment permanent endowment, that means it's used to provide an income for the charity. And if the new premises will not produce an income, then it may be difficult to argue that this is still an investment endowment. After all, if the governing document says, invest this money to produce an income, and you invest it knowing there will be no income, there's a good argument you're exceeding the scope of the power there. So legally, you might be in difficulty. The practical point is also that, as I've mentioned in my talk, it's just harder to sell functional permanent endowment later than it is to sell investment permanent endowment. For example, for functional permanent endowment, you might not be able to use the statutory process, and it might be harder to obtain an order from the Commission. You might have to go for a full-blown scheme. But what could you do if your clients are intent on doing this? Well, in my view, you may be able to vary the terms of the governing document to lift the investment element of the investment permanent endowment. There's a case from 1984 called Laing Trust, Laing, which confirms that restrictions on investment permanent endowments are only administrative restrictions. So that means you can lift those restrictions by going through the usual process of amending a governing document. So either using an express power of amendment in the document itself, or securing an administrative scheme, which is obviously slightly easier than a CPRE scheme. Also bear in mind here that clause 3 of the new Charities Bill will amend the statutory power of amendment, and the new section 280A, subsection 8A, will expressly allow the statutory power to be used to alter restrictions on permanent endowment. So if this happens to your client sufficiently far down the line, they may be able to use this new power, which should come into force in the next year or so, to change the restriction on the investment and then basically free up what they can do with the money. That's what I'd suggest we do there. All that's left for me to say is thank you very much for joining us once again. Thank you very much for joining us. Bye-bye.
Thank you.